Nice to see you all. This is a joint lecture between the Program on Artificial Intelligence and Law and the AI and Humanity Lab in the Faculty of Arts. I'm Scott Veitch, and I'm going to be introducing our speaker today, Professor William Lucy from Durham University, the law school in the north of England. William is an expert in areas of legal philosophy and private law. Some more people coming. And has been a professor at various law schools in England for some time. I won't say for how long. And has published widely in the area of private law and jurisprudence. He has also, as many of us have in recent times, transferred his focus or panned out, we might say, into issues of digital technology, digital governance, and the like. And it's that he's going to be addressing us on today. William is going to speak for around 40 minutes at the most, and then we're going to open it up for questions and discussion. The title, as you can see there, Law, Technological Management and the Future of Agency. Welcome, William. Over to you.
Thank you, Scott, and thank you everybody for taking time to come along. It's lovely to be in Hong Kong, and it's an honor to be here in the Hong Kong Law School, and particularly for a conked out old would-be legal philosopher like me. It's a delight to be speaking here under the auspices of the Paul K.C. Chung Chair of Legal Philosophy. There are very few endowed chairs of legal philosophy in the world that I've come across. So when there is one, it warms the cockles of my tired old heart, and it adds to the honor. It makes it even more special, it seems to me, to be here speaking as visiting Paul K.C. Chung, Professor of Law. What I'm going to be talking about today is law, technological management, and the future of agency. And forgive me if I roam around. I'm not particularly good at sitting still generally, and especially not when I'm talking. As Scott said, I'll try and speak for no more than 40 minutes, but saying that implies that I've got a kind of tightly worked out, nuanced paper to present to you, where we can move from one step to another, and will generate an interesting or stimulating conclusion. I don't have that. This paper is very much a work in progress, and therefore it's a kind of series of impressions. So if you find it alarmingly simple-minded, that's because it's probably alarmingly simple-minded, right? The paper that's the basis of this talk, if and when it ever gets written, is, as I say, now it looks like a vague plan. I think there's an interesting route from here to there. I think there might be an interesting conclusion to arrive at, but I haven't worked out the route yet. I've worked out some bits of the route, but not other bits. Hence, it's impressionistic, and hence you might find it alarmingly simple-minded. There's no guarantee, of course, that that when I finish the paper, it won't be alarmingly simple-minded. So what am I talking about, given the title? Legal regulation, technological management, and the future of agency. Well, what I want to do for you first is put in front of you two pictures of two different competing regulatory paradigms. And by regulatory paradigms, I don't mean, I don't have anything technical in mind. My use of the word paradigm has no Kuhnian implications for those of you familiar with discussions of the methodology and process of natural sciences. I don't have in mind a marker between normal science and abnormal science and so on and so forth. I'm just using the word paradigm in its kind of normal, non-technical sense as a synonym for model. And by a regulatory paradigm or model, I just mean to offer to you two distinctive ways of attempting to intervene in the social world to achieve a particular goal or bring about a particular situation or state of affairs. And the two different regulatory paradigms I've got in mind that I want to present to you are, on the one hand, the legal regulatory paradigm, and on the other hand, what I, following Roger Bransford and many other folks, call the technological management paradigm. We can use different terms for these two different paradigms, right? I don't kind of, I wouldn't die in a ditch and in terms of terminology. There are particularly different characterizations of technological management paradigm out there in the literature. But since I think Roger Bransford kind of used that term initially, and I think his characterization of technological management encompasses many of the other characterizations, I'm going to use his terminology. So what are these two different and competing regulatory paradigms? Well, one of them, the legal regulatory paradigm, is perfectly familiar to that cadre of folks we know in our societies that we call lawyers, and we're probably some of them as well here, and also to folks who are used to using lawyers to address regulatory paradigms, to address regulatory problems. And the default mindset of these folks, lawyers, when it comes to addressing a particular regulatory problem, I think looks like this, and I'll give you a very simple-minded example. But if we ask a lawyer or a cadre of lawyers to address the problem of speeding traffic in a particular community, I guarantee you that the first thing that this cadre of folks is going to do in response to that problem, and they'll see this as their job, what they'll do is something like this. They'll try and set a standard for traffic speed in that community. If there isn't one, they'll set one. If there is one, but the traffic's still going too quickly, they'll reduce it. They'll set that standard and they'll publicize it. What they'll then do is come up with ways of trying to enforce the standard. And there could be a whole range of enforcement options open to them. And what they'll then do, the third thing they'll do, is they'll try and give incentives for compliance or try and penalize non-compliance. So the three things that lawyers will almost inevitably do when they're called upon to address a social problem, three features of their regulatory mindset are right there just in that example. Set a standard, try and ensure the standard is enforced, and set incentives for compliance and penalties for non-compliance. Now, there's many other things that lawyers will do, but that, I think, is the core of the legal regulatory enterprise. And when we unpack that, let me see if I can go use this. When we unpack that mindset, the legal regulatory mindset, we'll see that it comes with a bundle of very interesting assumptions about the nature of regulatees, about the nature of regulators, as well as other things as well. And in other work, I call these two bundles of assumptions that underpin that mindset, the agential bundle and the rule of law bundle. And these, I don't put them before you as massive insights, right? These are absolutely obvious preconditions of the legal regulatory enterprise. What are they? Well, if we're going to go about, and I'm starting with the agential bundle, if we're going to go about intervening in the social world by setting standards, publicizing those standards, enforcing them, setting incentives for compliance and penalties for non-compliance, if we're going to intervene in the social world like that, then we're already assuming that our addressees can understand standards we set, are able to understand the meanings, standards we set out there in the world. Moreover, we're assuming that our addressees are not just able to understand our regulatory interventions in the world, but they also have the capacity to change their conduct in response to the standards we've set. It's absolutely ridiculous of me to set the date of 15th of November every year for the leaves in my garden to stop dropping from the tree. Yeah, I could publicize that. I've got signs on the lawn. No leaf fall after the 15th of November. If there is leaf fall after the 15th of November, I'll try and think of a sanction or something. But obviously it's not going to work because the tree, no way of understanding the standard I've set, my regulatory intervention. We're not actually on the same level of meaning, communication, etc., etc. So in the legal regulatory paradigm, regulators assume that regulatees are like them, that they have capacity for language and can understand language, can modify their conduct in response to that language. And additionally, at the background to both those elements of the agential bundle, there it must be an assumption about deliberative capacity. Not just that I can understand the communications that are made to me, and that I could, in principle, change my behavior in accordance with it. But that I can understand or understand communication in such a way that I can give it some thought, right? Okay, the speed limit now is 20 rather than 30. Fine, there are penalties attached to that. Will I abide with the new speed limit? Well, the regulatory intervention is designed to tilt my deliberative capacities, to tilt my deliberation in a particular way. The regulator is wanting the most salient option for my behavior to be compliance with the speed limit. But still, the standard is set and the direction is out there, but it's open for me to deliberate whether or not to comply, right? So one's regulatory targets, when one is an adherent to the legal regulatory paradigm, are beings capable of language and communication and understanding language and communication, beings capable of changing their conduct in light of that communication, and also deliberative beings, in the sense that when legal regulators set a standard, the standard is there to change the regulatee's behavior or to make one path more salient than another. And of course, of that very idea, path X is more salient than path Y, is the idea that you're able to deliberate and see that path X is more salient than path Y. And on the legal regulatory paradigm, there's no guarantee that regulatees will always do the salient thing. No guarantee at all. People will probably still speed in the neighborhood when we reduce the speed limit. Possibly not as many, possibly none, but still non-compliance is always an option on this picture. In addition to the agential bundle at the background of the legal regulatory paradigm, there's the rule of law bundle of assumption. And they're kind of built in to some of the assumptions that inform the agential bundle. If your preferred means of intervening in the social world is to set standards of behavior for other folks, try and enforce them and set reasons for or incentives for compliance and so on and so forth, those standards are going to have to be knowable to your addressees. They're also going to have to be understandable to your addressee. They're also going to have to be non-contradictory, relatively clear, and so on and so forth. We don't want standards that say speed limit here is 20 miles an hour for a while, or drive slowly but just for a bit. Drive so slowly when you feel like it, but not when you don't, all right? It's hard for our addressees to try and comply with standards that are like that are vague, contradictory, and so on and so forth. Similarly, it's hard for them to comply with standards that they don't know about, that we don't publicize, that aren't consistent, and so on and so forth. And what I'm saying here, in effect, is that within the legal regulatory paradigm, Fuller's 8 desiderata for the rule of law constitute the rule of law bundle. In addition to the background commitment for Fuller, which is weirdly reticent about in the morality of law, which is law is a means of subjecting human conduct to the governance rules. He's weirdly reticent because that phrase, I think, doesn't crop up until page 49 or something, or later in the morality of law. And it's absolutely fundamental, given the 8 desiderata, because they flow immediately from that conception of law's function. If law is a means of subjecting human conduct to the governance of rules, then you need rules. They need to be promulgated. They need to be relatively consistent. They need to be regularly enforced, and so on and so forth. So what I'm saying here is that the rule of law bundle that lies at the back of the legal regulatory paradigm is in effect Fuller's 8 desiderata and Fuller's claim about law's guidance function. And I should add, just in the matter of utmost caution, that when Fuller says that law's guidance function, that law is a means of subjecting human conduct to the governance rules, that's not an optimistic, or doesn't have to be an optimistic or charitable account of law and law's function. You could have the worst, most exploitative legal system you could think of, but it's still a means of subjecting human conduct to the governance of rules. We might think that the legal system we live under is a means of the economically dominant class upholding and enforcing its economic domination, but it's still also a means of subjecting human conduct to the governance of rules. It's just a means of subjecting human conduct to the governance of rules which ensure the economic dominance of the economically dominant class. So there's nothing particularly optimistic about Fuller's account of law's guidance function, for my mind. So we're not taking on any big, I think, substantive commitments in saying that law is a means of subjecting human conduct to the governance rules, and from that, the 8 desiderata follow. You might also think that saying the rule of law bundle is part of the legal regulatory paradigm will get us into some difficulties with, the supposed multiplicity of competing accounts of the rule of law. I don't think it does, because I think Fuller's 8 desiderata and his guidance function is the concept of the rule of law. And there are numerous different conceptions of the rule of law available to us, but all of those conceptions share the desiderata, that is, in Dawkins' terms, the shared argumentative plateau from which different discussions of the rule of law, arise. And I think if you want to talk about the rule of law and you don't have any room for Fuller's 8 desiderata and the idea that that law is a means of subjecting human conduct to the governance of rules, and I don't think you're talking about the rule of law. Most interesting conversations about the rule of law are ones that start beyond the 8 desiderata and law's guidance function. Okay, so that's the legal regulatory paradigm, and as I say, you may find that alarmingly simple-minded, for which I apologize, but we've got a relatively limited amount of time. It's a paradigm that's familiar to us, right? And the contrasting paradigm I want to flag up from you is the technological management paradigm. And the technological management paradigm in Roger Brownsville's characterization looks like this. And you'll see immediately that the technological management paradigm has a different list of regulatory quarries, if you like, or targets, that when we're doing this form of intervention in the social world, we've got a different regulatory quarry in mind, or quarries in mind, because when we're intervening in the social world in this way, what we're looking at what we're aiming our regulatory strategies towards are these things, not just fellow agents, right? Not just conceivably, not just other human beings, but human beings and other agents. What we're looking at when we're doing the technological management thing is, when we're intervening in the social world, the design of products or places, the automation of processes, so products, places, processes. Agents are not front and central there, right? The regulatory quarry is not fellow human beings, if you like, or agents necessarily. It's products or places, or the automation of processes, which seeks to exclude the possibility of certain actions in the absence of this strategy, which might be subject to just rule regulation, or human agents who would otherwise be implicated in the regulatory activity. So we're interested in products, places, the automation of processes. And our interest in that is to try and engineer a regulatory outcome that doesn't necessarily engage with these things, human agents. So there's no default in this regulatory paradigm that what we're aiming at is changing what folks do. We might be aiming at changing what folks do, but not through the medium of those folks, right? Not through the medium of their agency. If we go back to the trite example of the speed limit problem, the problem of speeding traffic in our neighborhood, I think a consistent technological manager will look at these things, products, places, the automation of processes, in order to engineer an outcome that they want, the outcome being fewer or no vehicles speeding. And one thing that a technological manager now would do would be to use the actual technology of vehicles to stop them speeding. It's available on your Tesla, right? On autopilot. It's there. It just has to be implemented to some degree. So we can stop vehicle speeding in our neighborhood just by ensuring that the vehicles will not speed. Full stop. However hard you put your foot to the metal, it's not going to go. And that looks like a clean solution to the regulatory problem. It's clean in the sense that you've now made non-compliance impossible. You're not kind of saying, look, we've reduced the speed limit around here. We want you to abide by it. It's dangerous when you exceed the speed limit. There are penalties attached to breaching the speed limit. There are incentives for compliance. We kind of set all that stuff aside here, because still, remember, when we do all that stuff, people can well speed, right? They could still decide to speed. On a technological management approach to that problem, make the problem impossible. Stop it arising. It looks clean. It cuts out all the legal regulatory stuff, all the silliness of posting new signs for the speed limits, all the enforcement mechanisms that might be necessary, and so on and so forth. Just manufacture vehicles that cannot speed. Brilliant solution to the problem. What assumptions are in play in the technological mindset? The technological management mindset? I don't think there are any, besides one of what you could call parsimony, I think, and efficiency. And here on the outline, I put that the assumptions in play in this regulatory mindset are zero, other than adopt the most effective, efficient regulatory response. And I'm not using efficiency here necessarily in a kind of cost efficiency sense. But the assumptions in play in this regulatory mindset are very few. Adopt the most efficient or effective regulatory response. And I think the key thing, which is usually the one that makes the problem or non-compliance impossible. So if we've got a social problem, the best response to the social problem, and again, I set aside questions about whether social problems are genuine or not and how they can be manufactured in folk panics and so on and so forth. I set that kind of interesting discussion and material aside. If there's a social problem on this view, the best response on this view, I think, is to make it impossible. Make it go away so it doesn't arise. So make the problem or non-compliance impossible. Whereas, of course, the legal regulatory mindset or the legal regulatory paradigm always allows for the possibility of non-compliance. Non-compliance is built in as a possibility to the legal regulatory mindset. Now, why does this matter? And I'm conscious that I've been droning on for a very long time about preliminary matters rather than getting on to what I think, for me at least, is the more interesting part of the paper, but also, and this could be an avoidance strategy, the radically incomplete part of the paper. Before moving on to the kind of second part of the paper, why does it matter, this conflict between the legal regulatory paradigm and the technological management paradigm? Well, I think one of the reasons why it might matter, there may be many, is that I'm not claiming the technological management paradigm is new, by the way, right? That would be silly, because I think a pyramid is a technological management response to a social problem. And they're pretty old, right? But I think what's interesting and what's significant about our current moment is that the existence of what's called data-driven agency here, or algorithmic regulation, in our communities, in our societies, means that we could be living with a form of technological management regulation carried out on the basis of deep neural networks, not necessarily recurrent neural networks, language models, large language models, and so on and so forth, connected to each and every one of our micro devices, our kettles, our smartphones, our fridges, our cars, traffic monitoring systems, and so on and so forth. Those technologies pulled out the prospect of a context in which we can be quite comfortably and easily technologically managed without knowing we're being technologically managed. So I'm not saying technological management is new historically, right? Think the pyramids. What I am saying is that the changes in our societies as of now mean that technological management is available much more broadly, much more widely, and conceivably much deeper into the fabric of social life than it ever has been until now. And that's the kind of claim that's at the back of my answer to the question, why does this matter? It could matter for this reason. We could be in a historical moment where technological management is more easily, more widely, more deeply available than it ever has been. And technological management holds out the prospect of regulation without knowing we're being regulated. We could well be regulated in many fields without knowing it already. So I'm not saying necessarily this is qualitatively new. Might anything interesting follow from this transition? Because here's the other claim. The direction of regulatory travel, as Brownsword puts it, is from the legal regulatory paradigm to the technological management paradigm. I think he's right about that. That is the direction of travel. Given that we're on the cusp of this change, given that we're moving along this path, is anything interesting flowing from it, except what I've just said about technological management now being available at a scale that it hasn't been available before? And there are possibly two things. First, I've said this already in a way, we're in a domain of and a time of regulation by AI, not the regulation of AI. And secondly, and this is the thing I want to emphasize in the next 5 minutes or so, in this transition from the legal regulatory paradigm to the technological management paradigm, it seems to me interesting to speculate about what, if anything, the impact might be on our notion of agency. That it seems agency in the face of technological management seems like an interesting issue, particularly if as I've just said, that now technological management is available to us at a scale, in a depth, and so on and so forth, that it hasn't hitherto been available, that we might be being regulated by it without knowing it, and so on and so forth. Does that have any interesting impacts on our understanding of agency or the nature of agency? And my answer to that question is I'm not sure. It might do. And that's, I think, the kind of question in the paper so far. Second part of the paper is about this agency in the face of technological management. If we're living in a world of technological management, what will agency look like? Will it be impacted? And so on and so forth. Now, to answer that question, obviously, one needs an account of what agency looks like. And the account of agency that I want to unpack in the paper, but haven't yet unpacked, is that agency in general, both in philosophical terms and in general common sense terms, looks quite a bit like that picture of agency I've already provided to you that lies at the back of the legal regulatory paradigm, the agential bundle. What it is to be an agent in the world is to be aware of the world, to be aware of your interaction with the world, and to have some control over your interaction with the world. And philosophically, I think that's an interesting account of agency because it allows us to distinguish agency from autonomy, which many jurists and philosophers are loath to do, as one of my colleagues at Durham said to me in a discussion about this. There's zero consistency in the use of the terms agency and autonomy in the philosophical literature. I think it's worth imposing some consistency, and I think the consistency is this: that what I've just spoken to you about as agency is quite different from autonomy. That agency is a precondition for autonomy, but it's not the same. Autonomy is a much deeper notion than agency. But this thin notion of agency is philosophically useful because it allows us to distinguish agency from autonomy. But also, this thin notion of agency is one that we find ordinary folks talking about. Now, a number of my colleagues do work lots of different areas, but some of their work is empirically based. And here's one thing that a lot of folks say in a lot of different contexts that I've gleaned from my colleagues. Women subject to obstetric violence, one of the things that they say that they find most objectionable to obstetric medical procedures when they're involved in them is we weren't consulted. We didn't have any input in the process to the medical procedures that ended up being perpetrated on. And we weren't even told about them in some context, hence obstetric violence. And what those folks want is to be engaged in the process, as I would say, agents, to know about the world, to know about what's going on in the context that they're in, to have an input into those processes, to be consulted in that processes, right? Engagement with the world and the particular social bit of the world that are involved in. Similarly, victims in the criminal justice system say much the same thing about the way the criminal justice system often works in my jurisdiction. We have no idea what's going on. Yes, we get a date for the trial, but that's about it. No one asks us about whether we want to take part. No one really bothers with what we have to say until we're listed to give evidence if we are, and so on and so forth. And there are lots of other contexts in which this, what I call common sense conception of agency, of being engaged, deliberatively engaged in the world, consulted by the social world, is in play. There's a lot of interesting research in the domain of social work practice and theory that seems, at least on my superficial view as yet, to generate the same kind of result. That when social work processes in our communities are working well, folks who use them and are engaged in them are engaged as agents. They're consulted, they have some input. Restorative justice developments, also good ones, emphasize those kind of matters. So that's what agency looks like, I think. There's an echo of that view in the legal regulatory paradigm. That view of agency is not obviously autonomy. And if I'm able to unpack that view of agency, I think I can get to this tentative conclusion here, third bullet point, which is that technological management as a regulatory paradigm, as a way of engaging in the social world, is not obviously, excuse me, is not obviously agency enhancing or agency respecting, and it might even be agency denying. And when things get even more crazy than they already have been, I think, if you're with me so far, that issue, that claim that technological management is not obviously agency enhancing, not obviously agency respecting, might even be agency denying, I think that claim commits me to the following. It commits me to being able to quantify, not just recognize, but quantify agency. And hence, the fourth bullet point here is recognizing agency denial and counting agency denial. And you might now think, if the alarm bells are not already ringing, that this sounds, how might we quantify agency? Given the account of it I've just put in front of you. And I got a very lazy answer. It's a quick answer, given that I've taken too much time talking about other matters. I think we can quantify agency in the same way that Hillel Steiner, Ian Carter, and Matthew Kramer, to name but three, folks have attempted to quantify and measure freedom. And Ian Carter's book, A Measure of Freedom, defends what he calls an empirical picture of freedom, but thinks we can count, we can quantify freedom. And he goes down that path for a quite obvious reason, right? We're all saying, it might be a mistake, it might not. Oh, well, people there are freer than people here. People in X community are less free than people in Y community. And the first chapter of Ian's book lists many instances of that kind of ordinary way of speaking. And it's a way of speaking about freedom that suggests it can be quantified. And Ian takes us at our word in that and says, well, all right, if you folks are going to go around saying that people in society X are freer or less free than society Y, then you're committed to being able to quantify freedom. And Ian, taking Hillel Steiner's lead, goes about doing that. And he claims he does do it in A Measure of Freedom in his subsequent work. Carter's work has been added to by Martin Van Hees and two social choice theorists, Pasternak and Zhu. And there's some significant complexities here. Not just the complexities in distinguishing between act types and act tokens and counting them, but also because, for example, Martin Van Hees thinks that's a dead end. We should be comparing not act types or act tokens and trying to count them, but opportunity sets. And that lies at the basis of our comparative judgments of freedom. For present purposes, you'll be glad to know, All I want to say to you is that my argumentative hunch here is that we can quantify agency just in the same way as Steiner, Carter, and others, Van Hees, Pasternak, and Zhu, quantify freedom. And if we can do that, then we're able to cash out potentially the claim on the previous screen there, which is technological management is not obviously agency enhancing or agency respecting, it might even be agency denying. Because I think, as I say, underlying that claim is the possibility of being able to quantify agency. And if we can quantify agency in the same way as Steiner, Carter, and others quantify freedom, then we can cash out that judgment. Last couple of points on this, and I'll spare you any more of me droning on. I mentioned data-driven agency in an earlier screen, as characterized by Muriel Hildebrand. And one thing I want to flag up about that is that in our technologically managed future, where we're being regulated by AI, not regulating AI, there could be a similar quantity of agency in the world as there is now. It's just that some of that agency belongs to data-driven agents and not human or non-human agents. And I can't help finding that deliciously ironic and troubling from my own argument. Because I'm the one who wanted to start counting, right, and quantifying agency. And the riposte could well be, well, there's actually more agency here because there's data-driven agency in the world. Okay, there's less human agency, but who cares about that? He said rhetorically. That doesn't matter. So there's an issue about the amount of agency and the distribution of agency here. That on the horizon of my argument, if it ever gets cashed out, would be troubling and irksome and annoying, and it would make me laugh too. And another kind of irony and argumentative irony, which is not on the screen here, is some of the complexities of quantifying agency, of measuring freedom. And the complexities are quite demanding. It seems obvious to invoke AI to count act tokens or act types or opportunity sets and thus churn out a quantification of agency or freedom using the technology that's at the back of some of the worries in the paper. And again, I like the annoying irony of that. Sorry, I've gone on 5 or so minutes too many. That empty screen there really characterizes my thinking at this point. There's nothing to it. And finally, this screen was just an afterthought. I realized that we used this background for our lectures in legal philosophy on Republican freedom. And one of my colleagues found these exponents of Republican freedom, I think. And I just thought I'd finish with that as a note of silliness and levity. Thank you for your attention. Apologies for talking so long. I'd love to hear your questions. I mean, the payoff for me in this presentation is you can say that series of argumentative impressions, just crazy. Forget about it. That's a win-win for me. It might even be, oh yeah, it's worth pursuing. I'm not sure what the payoff for you guys is in having sat through those 50 minutes, but there's a payoff for me, and given that there's a payoff to me, I'll thank you for your attention and be quiet. Thanks.
Thank you very much, William. A very clear exposition of these two paradigms and some route through them. Let's see if there are questions or comments or observations. Yes, a couple up the back. Yes, please.
Sorry, given your picture, I sort of then linked my head. Yeah, linked to this year, which is the American election, which I call it the year of the stupid, you know, see how low could you go in a limbo stick. But having said that, there seems to be that politicians would tend to want to move towards a system of accountability, or your management system in a Foucauldian sense, without the head, the legs and hands would move. I wonder whether there's an attraction to the notion from your agency to make humans and technology in a codependent relationship in terms of regulation. That seems attractive. But of course, we have the question whether human can control, which is the other funny thing. But do you think there's an attraction towards that ideology?
Sorry, I've switched the mic. And I don't dismiss that at all. The ameliorative tendencies there in Gail Hildebrand's most recent book. I'll put them up.
It's not clear as you think it is.
Right, sorry.
It sounds that it's not enough.
So that ameliorative tendency is there, and it's there in the title of Muriel Hildebrand's, I think, most recent book. It's Law for Computer Sciences, Scientists and Other Folks, and it seems to me a perfect illustration of that. I mean, Muriel's a bit less optimistic about the ameliorative strategy, the combination of techno management and legal regulatory fields, but it's there in the book, right? Because she wants computer scientists, the folks designing many of the systems that we're living through or under, to be informed about the nature of the rule of law. So yeah, I mean, I fully accept that. I don't really take a view on ameliorism or not. I think if I have a worry here, my worry is that the drivers of these technological changes in my bit of the world are just large corporations, and they rarely have our best interests at heart. We might benefit from what they do to some degree, but so I'm just skeptical about that. That's but the ameliorative strategy seems worth pursuing, and it's worth talking about. And if all computer scientists studied Muriel Hildebrand's book in their second year, as well as coding, I think the world in 5 or 6 years could well be much better in that respect. And my own colleagues in computer science are going down the same path. And there's grounds for optimism because of, I think that we tend to sort of tar them with just a limited techno brush, that they're only interested in the immediate changes of the code, and they don't have the broader picture. They do actually, and they're interested in talking about the broader picture. But yeah, I might have mangled what you were saying, but I think that ameliorative strategy well worth taking and talking about, if I haven't put words in them.
Okay, thank you. Alan?
Alan, hello.
Hi. Thanks very much. It was very stimulating. So I guess my question is a bit of a follow-up in the sense that kind of ultimate normative horizon that seems to travel through your expose is agency and individual autonomy, right?
Well,
Agency, yeah. So it seems to sort of leave out entire question of whether each of these paradigms that you've identified are in sustaining or enhancing a particular form of government. So if when we were going through these different paradigms, I was thinking, well, the regulatory paradigm seems to be at least echoing or reflecting a very neoliberal form of government in which individuals are basically they're little entrepreneurs, to use a term that neoliberal theory uses, right? And that's why non-compliance is very much still an option in that paradigm. equally, when you describe the technological management paradigm, it seemed to me that it does kind of match the most recent definition of authoritarianism as a form of government. And so I was surprised that you do not at least connect both sociologically, in the sense that these different paradigms might have been engineered by these forms of government, or at least theoretically that it could serve these forms of government. So I wonder why you do not link these, whether methodologically you resist that ultimately.
Well, look, don't wonder about that. The answer is, I just haven't done that. Right? And I haven't done that not on grounds of principle or reason or anything like that. It's just that this is a limited part of a piece of work. And now you've mentioned it, it seems to me that the broader sociological context in which these paradigms are emerging, it would be marvelously interesting and fruitful. And as you characterized it, right. I guess my only response to that is, well, get on with it, will you? Because I'm busy with this. I mean, this is just one installment and one essay. And given my interests, I'll probably end up pursuing that more philosophical angle to the project. But there is undoubtedly the broader socio-cultural and economic context, right? Now, I suppose you can berate me then, and we can get into an argument and say, but the socio-political economic context is more important than what I'm droning on. Then I guess we could have an argument. I guess my only reply to that is, well, it might be, it might not. We'd have a discussion. We could have a discussion about that. So, I mean, point taken, but also slight riposte in that got a limited amount of time, and these are where my interests align. But that broader context seems to me to be a marvelous chapter, contextualizing chapter in a series of essays on this. One of which I might be editing with my colleagues in computer science. So Durham, and I've now got you in mind. Not sure that answers your question, as opposed to Harry's.
No, it absolutely did. I would just add that. So you mentioned the ways in which this, especially the technological paradigm, might frustrate individual agency. But it could also very much completely frustrate democratic agency. So it's exactly, you're describing something that it's not the story. Your story doesn't seem to change much when you add the kind of political dimension of it, right?
Well, I'll take your word.
Okay, we have another question. Herman.
Thank you. That was really interesting. I'm trying to get my mind around the technological management category a little bit. So you can go back to the case you had, the car and the speed limit built into the car. Are you thinking also like the decision to make a one-lane street rather than an autostrada or just one lane street instead of a motorway? That kind of restricts how fast people can go. Speed bumps, restricted turns, having a turn and not just straight. So there's a lot of decisions we make about the physical infrastructure of the world around us that restricts all kinds of behavior, pretty much on analogy with building something into the cars, and we don't want people to buy electric chips and travel around with them. No. Is that part of the category?
But no, it is, but there is a series of moves from which can move from one to the other. And in actual papers and in more time, I can sketch out how you can move from one to the other. Because what we would say of our legal regulator is, our legal regulator, he or she are not very smart, just setting a speed limit and systems for enforcement and incentives for compliance. Because what a smart regulator would also do would be perhaps intervene with the physical plant or architecture of the environment, right? Make the road narrower as well, yeah? Make it single lane. What a smart regulator might also do is, in addition to intervening with the architecture, and I'm just parroting and echoing Lessig's fourfold division here, is engagement, right? Which is relatively common in some of the communities I'm familiar with. So in some communities, I don't just see speed limit signs. I see signs that say kids play here, play zone, quiet zone. Those signs appear a result of the local community, the local authority, engaging everybody in the community in responding to this problem. Because the people who drive through the community are not outsiders, not residents. Sometimes they are, but they're not. And folks just need to be reminded of their responsibilities. Kids play, your kids might be playing, all right? So we can move from the rule response all the way up to the technological management response by a series of steps, and the spectrum just moves along, right? However, I think when you end up at the technological end, full-blown technological end of the regulatory spectrum, it's a really, really different place on the rule regulation starting point, right? But the steps can seem incremental and tempting because we're going to say, don't just change the limit, put some signs up, narrow the road, make it one way, and so on and so on, right? So there's a series of steps there, and you're absolutely right. And a smart, so-called smart regulator, and I use smart in the old-fashioned sense, not technologically IT, AI smart in the sense that it used to be used in the 1990s and 80s of regulators, that smart regulators are folks who just draw upon a plurality of options and menu choices in order to solve the problem. That's what a smart regulator does. So you'll do all those. See them. But I just drew the 2 points to make the contrast as vivid as I could, and making it vivid in order to flag up the fact that if we end up at that end of the spectrum, the technological management spectrum, might there be some agency-related worries about that if we end up? So you're absolutely right.
Okay. Thank you. It's 1 o'clock, so I know people have to go on, but we have a bit of flexibility. There's no one coming into the room, so we can keep going a little longer. Brian.
Great. Thanks so much for the sharing. I was going to phrase it slightly differently from what was done earlier on, but the phrase that came to my mind was kind of 2 aspects. So one is kind of the who watches the watchman kind of question. So on the one hand, there's the totalitarian leaning, right, in terms of who dictates.
Yeah.
And the second one is you're assuming whoever codes it, has done it right, shall we say. And that's what a lot of the thoughts around AI governance is now about. How do we govern the data that goes in, the models that go in, and the like. So maybe that's so your framework reminded me of Lessig's kind of architecture and the like. We're all going online and absolutely, and now with the blockchain we can include and we can track everything. So I was just wondering, so those were some observations. But the question I had was, you talk about agency, but I wondered how the concept of accountability then came about, because a lot of law really is about who is accountable and humans being accountable for actions, as opposed to, oh, I have no agency or / accountability because the machine, I'm just following what the machine's told me. Thanks.
Yeah. It seems to be that the use of automated decision-making systems in public services, in large chunks of public law, in the bit of the world I'm familiar with, it is just a brilliantly fruitful ground for that kind of agency denial. It's not me, it's the system. And recently in the UK, the post office scandal that involved a number of people being convicted, obviously not an AI system, but the computer system, a number of people being wrongly convicted of serious criminal offences. It seems to me entirely on the basis of the halo of a technological system, right? Because it could not be accepted that could be wrong. So that when postmasters and mistresses and so on and so forth went before the courts and said, I didn't embezzle tens of thousands of pounds, it's a fault with the system, That was kind of unthinkable until now. Yeah. So there's definitely a halo effect to automated decision-making processing technology. And they do facilitate kind of agency denial in a way. I know colleagues at other universities in the UK working on automated decision-making in the public sector say that the human in the loop stuff really just means human in the building. So immigration, visa decisions, UK Home Office has enrolled an automated system, they claim one of the biggest in Western Europe. It could well be the most ineffective, the most unjust for all we know. But they also say, officially at least, that there's a human in the loop. But the people who study the system think just in the building. Yeah. Sorry, now I've gone on all that stuff, but I forgot about your question. Was it about how we can build in accountability? Right. So I think there's accountability at general level as one human being to another, full stop. Yeah. Just as virtue of being out as being agents, we're accountable to one another. I bump into you, I say, oops, sorry, and so on and so forth. That's what you might call everyday moral accountability. And I don't think, unless we're moral imbeciles, we're going to escape from that. I think the more interesting political and policy sense of accountability is the answerability of those who deploy power over it. Yeah. And I don't think automated decision-making systems have anything like that built in. Now, to have it built in, I think they would have to be intelligible to human beings. The outcomes, I mean, right? And if we think of the outcomes of deep neural networks, never mind large language models, the outcomes those things develop are utterly unintelligible to us. The amount of data that goes into the data training sets is beyond our comprehension. If they're kicking out outcomes that say, yes, Lucy can stay in the country, no, he can't, for that to be an accountable form of decision making, it's the deployment of power over me. I'd have to be able to understand it, you know, and we can't understand it. And computer scientists tell us they can't understand it. And also, I'm a bit more skeptical than you on the basis of my computer science colleagues about doing something with the data. The data is bad. It's racist. It's discriminatory. It's gendered. And it's a load of, sorry for the bad word, language, it's a load of crap. If you put that in your training data set and your algorithm cranks out outcomes on the basis of it, they're going to be bad. And the classic ones, we all know the classic ones, right? Facial recognition systems that can't recognize particular skin tone. Might recognize my face, won't recognize somebody else with a different skin tone, or will regard them as a different species. And I know there's a lot of work on modified and artificial data in training sets now with computer scientists. Just to me to put a sticking plaster on something that's just really, really hemorrhaging a lot of blood, right? If you've got a data set and an algorithmic, say, facial recognition system that can't recognize 50% of the human beings on Earth, something really badly wrong with it, right? And synthesizing artificial data seems an inappropriate response. So accountability, I don't think is in those systems because I don't think intelligibility is in them, human intelligibility, and that worries me. And I base that worry on the basis of what experts tell me. Yeah, I know there's a lot of anecdotal evidence out there, but the actual experts, the computer scientists, tell me the data is terrible and it generates terrible results. And of course, it exacerbates because you train your network on bad data, it exacerbates the bad result as well. And there's a mathematical function to show that. I can't explain it to you, but I've been shown it. So at which point, you know, I am deeply, deeply troubled. So yeah, I'll stop ranting.
Okay, we've just got, are there any other questions? There is here, yes, sorry.
Most concerned with
Thanks.
I hear these things.
Yeah, so the concern I have is, so say we touched upon the issue of artificial intelligence, say going rogue, say that it made certain derogatory remarks or that it has entered into certain, well, let's not go into the tort aspect first because I think that's more slightly complicated. Let's say using our contractual side of things and say that you enter into, you input some data into an AI and then it spews out something.
Some homophobic, racist
Yeah.
garbage.
So yeah, so say putting that side apart, but let's just say it's entered into a transaction. And bearing in mind the premise that what we discussed earlier, that the person who input the data likely has no control of what would come out. But nonetheless, it remains as something has come out. I was just wondering, say if I ask for a claimant in these circumstances and I want to hold the person who input the data as being liable, can we do that on grounds of traditional agency principles? So say ostensible authority.
What, like agency?
Yeah,
and then
agency
contract?
relationship. Yeah, because
Oh,
I'm
wow.
thinking that
You're
if-
asking the wrong person.
sorry.
Asking the wrong person.
Okay.
I mean,
Yeah.
agency.
Yeah, agency.
Yeah, okay. I guess my answer to that, Thomas, is perhaps. but which is another way of me saying, I don't know. Actually, I have no expertise there. So.
Or just to follow on that question, do you think, and this is a more general question,
Yeah.
is that do you think, say, an AI who is capable of independent thinking like this,
Yeah.
is there any room for saying that they should have a separate legal personality
Yeah.
than, say,
Yeah.
the inputter and the reason behind?
Yeah. Yeah. So I'm with my computer science colleagues on that, which is even when it comes to large language models, these are just next, for them anyway, these are just next token prediction machines. So they're much the same as neural networks. What they're doing, and recurrent neural networks that we use for translation and so on and so forth. What they're doing, given the word vectors that are fed into them, is predicting the next word that's going to come along. And that's not judgment, I don't think. And they don't think either, right? I mean, some of them do read Kant, but not many of them. I've got a kind of Kantian defense for that because I don't think you can you can use a rule to teach people about the application of rules. So I think there's a kind of fundamental difficulty there. So judgment's probably not on the agenda. But some of the things that large language models do, setting aside the hallucinations, right, when they make stuff up, just look weirdly creative. And it looks more than next token prediction. Yeah. So you know, the Lucy and then ass, these always occur together in the lexicon. They seem as they're kind of unfolding now. And of course, now that they're able to start programming themselves, they seem to be being creative over and beyond next token prediction. But I'm still uncertain that that's judgment. And I guess, again, just to parry your question, I'll just stand with my computer science colleagues on that too, and I'll say that's what they think, and just leave it at that. And the agency thing, you're asking the wrong. Sorry.
Well, we've gone over, and I'm sure there are many thoughts being provoked. Certainly, I have many, but I will spare you them right now. Yeah, and some pictures as well.
That says, "Oh my God, will this never end?"
Please join me in thanking William for a very thought-provoking.
Well, can I thank you for your questions and taking time to be here?